and that's what will happen. And then do you see the button to share your screen?
I had lost you for a moment.
Welcome to Learn and Work, a webinar series presented by the journal Work, a journal of prevention, assessment, and rehabilitation. I'm Amanda Nardone, the editor's assistant for the journal, and I'm moderating on behalf of the founding editor, Karen Jacobs. We're delighted that you could join us today. I'm going to be brief so you get to hear from Dr. Brian McMahon with his presentation on workplace discrimination and hearing loss before and after the ADA Amendments Act. All right, I'm going to turn it over to you.
Thank you, Mandy, and thanks to Dr. Jacobs for her invitation to this occasion. My name is Brian McMahon. I'm a full professor of mental health and rehab counseling at Virginia Commonwealth University. I'm a psychologist by training, an organizational psychologist, and also a certified rehab counselor, licensed professional counselor. I'm here today to talk about my special area of interest. I'm somewhat of an older presenter, probably as far as these things go. I'm 69 years old. I've been 48 years in the business of rehabilitation. And for the last 30 or so years, I've been very involved with the passage and implementation of the Americans with Disabilities Act. And all my research has been focused since the early 90s anyhow, on that particular law. And we submitted this article, Workplace Discrimination and Hearing Loss, before and after the amendments. It's in the February 2020 Journal of Work, volume 65. And I'll be summarizing that and talking about some of its implications and some of the reasons why the ADA is so important and how it's unique for people with hearing loss, how they experience discrimination differently, as well as comparing and contrasting them with other groups. Thank you again so much for this invitation, and those of you who are not legal scholars, you don't have to be, or really deeply invested in disability studies, you need to know a couple things about ADA, and they're both on this slide. The ADA in 2 sentences says that all personnel actions must be unrelated to the existence or consequence of disability. But for employers, some personnel actions place them more at risk than others. The other aspect of the ADA is everything in human resources in a workplace organization in America, if you employ more than 15 people, is subject to accommodation, if that accommodation is reasonable. So the ADA passed in 1990, and we have data about how it's performing and behaving all the way to 2016 inclusive. Pretty soon we're going to update it to 2020 inclusive. That'll bring us a lot more allegations and make our findings even more reliable. But you'll see, you'll learn about that in a moment. But why did the ADA need to be amended? And the reason is, in brief, after the law was enacted in 1990, became effective around 1992, the Supreme Court began to whittle away at the law in the late 1990s, and really weakened the law through a series of 3 Supreme Court decisions known as the Sutton Trilogy, S-U-T-T-O-N. And these Supreme Court decisions weakened the law, and Congress became a little bit upset at that, particularly, and so did President George Bush, because his father was the person who signed the ADA into law, and the Congress and the president overwhelmingly passed the amendments in 2008 that restored the strength of the ADA so that more people with disabilities would be protected, more people would have a working mechanism to file their grievances and remedy any breach of the law that was discovered. So that process was very, very exciting, and the law changed and really did become invigorated. So it's really fun to participate in providing data and research information to the Congress and to the parties that were arguing back and forth, the business community versus the disability rights community in 2007 and 2008, and see not only that amendments and corrections were made to restore the integrity of the Act, but also to see that people's rights were being protected and that Congress can be responsive to the will of the people when they follow the data. And if you want to know more about the amendments and how the law was before and after the law, there's a citation there, a pocket guide for rehabilitationists that I wrote, was published back in 2010, shortly after the amendments were effective. We have a project here called the National EEOC ADA Research Project. It's currently being moved from Virginia Commonwealth to the University of Kentucky, but I'll stay involved with it. I've been directing that since 2003. So the EEOC is the Equal Employment Opportunity Commission, and this is a branch of the Department of Justice, and they enforce all civil rights laws with respect to employment. So the EEOC is not to be taken lightly. They are a law enforcement agency. They don't walk around carrying guns and badges, but they do receive complaints from protected classes of American citizens. And for the people with disabilities, that means the ADA. So under Title I of the ADA, the employment provisions, they do accept charges or complaints and investigate them quite thoroughly, usually for about a year, and then render some judgments in terms how an employer, if guilty of discrimination, can remedy that breach of the law, or if they are not guilty of the allegation, they are free to go about their business again. We take I work in a college of health professions, and we take a public health perspective on workplace discrimination. We see it like you would see a virus. This slide is 5 years old, so it's not a response to the coronavirus today. We see it as a very un-American type of behavior for employers or anybody to engage in. And if you want to read a good historical book about recent large-scale violations of the ADA, the New York Times reporter Dan Barry has a book called Boys in the Bunkhouse, and it's really exciting reading and also a good layperson's rendition of what the ADA is all about. I highly recommend it. So what do we have? I have all the data from the EEOC from the start of the ADA in 1992 through 2016, so almost 24 years of data. And in that database, I have the universe of reported complaints or allegations about discrimination against Americans with disabilities. I want to point out to you that this is the universe. These are population statistics. These are not samples. These are every closed case of EEOC reported investigations from 1992 to 2016, 823,500 unique allegations. For each allegation, I know 5 things. There are 5 variables that we study. And those are, what are the characteristics of the person with a disability who brings a charge? The EEOC refers to this as the charging party. We know their impairment, we know their age, gender, and ethnicity. The purple is what state or region of the United States did the employer host their business, where this allegation was filed. The third is the employer themselves. We know the number of workers, and we also know their industry code, but that's a very unreliable field, so we no longer study the industry code until we can make that more reliable. Down in the orange in the lower left is probably what we call the sexiest area of disability research study, disability discrimination study, and that is the types, the 24, 25 types of discrimination that occur. If you look in the little boxes, you see some of these issues, as we call them, refer to getting a job. In the middle, work conditions, and on the right, keeping a job. And you see that these are typical personnel activities that you as a worker or as a supervisor, boss, or owner, or even as a customer encounter in interaction between people and their jobs. Things that relate to getting a job, like hiring, things that relate to losing your job, like firing, things that relate to working conditions, like wages and benefits, your job classification. They're all grouped there. There are 24 possible issues. This is really, what is the nature of the complaint? What is the complaint alleging? What is the charging party alleging that is unlawful in terms of the personnel activity, specific personnel activity involved? And then fortunately, we have the outcome of the resolution after the EEOC investigates the allegation for 6 months to a year. It can be, did the decision from the EEOC favor the charging party? On the left, you can see things that would represent that, negotiated settlements, when the person withdraws their complaint with benefits, or when there's reasonable cause. Those are called merit outcomes. On the right, you see no cause outcomes. These favor the employers. Obviously, when there is no merit found in the case, in other words, the evidence provided did not rise to the level where a likely discrimination event actually occurred. It was more the perception of the charging party. And another type of non-merit closure would be an administrative closure, where a case was dropped because of a technicality, administrative technicality. And we'll visit those again later. But that's some of the language that you see a lot. And the key words to remember there are: the charging party is the person who's filing a complaint, the respondent is the employer, and the case ends up with a resolution, which is either merit or non-merit. We do a lot of heavy lifting on this project. Just briefly, we're over, the slide's a little dated. 10 students have completed dissertations using this data. We're at about $4.5 million in total grant money over those many years. And we have about 90 publications in print now, involving about 90 professors and doctoral students from over 20 universities around the United States. So this is not my work exclusively, although I am involved with every, as the director of the database, I'm involved with a position and consulting or advisory capacity on every article. And it's not just Virginia Commonwealth University. As you can see, we have people from another 19 or 20 universities that work with us and publish with us regularly. What kind of studies do we produce? These 90 publications, what types of things can you do with this data? What kind of things can you learn? Well, we study the characteristics of employers or the characteristics of the charging parties to see how those things make a difference in the outcome of the case or the issues or nature of the case. We study the issues themselves, things like hiring and firing, disability harassment, failure to accommodate, the terms and conditions of employment. Those are things that are of great interest to us. Can we predict merit? Yes, we use risk ratios and discriminant analysis, and we're literally able to predict when a allegation is filed, who's going to, if you want to use a coarse term sort of, who's going to win the case at the end of the investigation. We can predict those with the data we have on the basis of good analytical techniques. we can predict the investigation outcome, how the case is going to end up decided, with about 96% accuracy. We can do impact studies. We study the impact of the Supreme Court decisions. The Sutton Trilogy brought that data to attention to Congress when they were negotiating what the amendment should look like. The impact of the amendments is exactly what we're studying today and presenting today. The impact of the amendments on a single insular group of people with hearing loss, to demonstrate for you how that works. We published on the impact of the Great Recession from 2007 to 2012. And so too, we can look at all kinds of timeline trends in terms of emerging disabilities, the course of a particular disability like HIV, which of course was regarded very differently in the workplace in 1990 than it is in 2016. The influence of labor unions, right to work laws, there are all manners of things. And these topics that we study are brought to us from the field. There are things that are not things that are my pet issues or concerns or relate to impairments that I may happen to have. There are things that come to us from a variety of employment organizations and advocacy organizations say, could you help us understand what's unique or different about, let's say, multiple sclerosis. So the Multiple Sclerosis Foundation has funded almost 9 or 10 studies now, led by Dr. Rumrell at Kent State for the most part. And they have probably a better understanding of how job discrimination works for their population than most of the other 1,000 impairments you would find in the International Classification of Diseases. So here's the yield, about 90 articles. We published in 13 different journals. These are the most popular ones we published in. And when we publish, we often bundle 5 or 6 publications and put them in a special issue. We've done that with Work 1 or 2 times. Work is one of our favorite journals. And that's why I was more than happy to come and do this webinar at the request of the leadership of that journal. It's excellent, as are the other ones we try to choose. And notice that at the bottom, we also publish from time to time in business journals, HR journals. They're very interested in these organizations, not just particular vocational rehabilitation, ergonomics, or disability populations. I thought I'd just maybe tease you for a minute, maybe 5 or 10 minutes to talk about some of the new knowledge that comes out of these studies that's not necessarily pertinent to deafness, but obviously when you do this level of big data analysis, you find surprising things. And these are some of the surprising things that we've learned. One is you oftentimes hear that when the amendments were up for approval, you get battle lines are drawn between the business community and the disability community and their advocates. And the business community always, when the law was first passed, as well as when the amendments came up in the year 2008, crying foul. That there's a tsunami of more litigation that will come, that business is overburdened with regulation, and that this is just so much social engineering and large-scale attacks, not on the disability community, but on the law and on the regulators and against the EEOC. The fact of the matter is, if you employ today 1,000 workers, first of all, you're probably very wealthy, because only 2% of employers are this big in the United States. The odds that you would get a single complaint under the ADA in every given year are about 1 in 5,000. So the notion that these things are tremendously burdensome, there are only about 50 law cases, that would be high, about 30 complaints that go all the way through a jury trial. The EEOC and labor unions deflect so much of the complaint process, but just that you would see a complaint filed is less than 1 in 5,000 per year. And that's if you had 1,000 workers. So that's all exaggerated. And it was helpful at the time of the amendments to point that out to Congress and remind them that this is not unduly burdensome. Second finding is, remember I told you there were 24 personnel issues, types of discrimination, hiring, firing, so on. If you take the top 5, they account for 76% of all allegations. So imagine that. For over 10 years, I was out training employers on the ADA about how to comply in 24 different ways. When in 19 of those 24 different ways that you can discriminate, there's almost no activity. So how much more efficient would it be if the employer can direct their compliance resources and their efforts at reducing discrimination in 5 types of personnel behavior? Obviously, much more efficient, because if you could eliminate these 5 problems in your workplace, you would virtually have, you could lower the allegation activity that you're dealing with in the entire business community by 76%. So we really then started to zoom in on understanding firing, the failure to accommodate, terms and conditions of employment, harassment and intimidation, and hiring, because that's where the action is. And until we began to unearth facts like this, the EEOC was even extraordinarily surprised to see that their compliance efforts and regulation efforts, as well as the employer's investments and risks and risk mitigation, could all be improved by focusing on these 5 things. That's important finding number 2. Number 3, employers need to be told and understand if they get a complaint, stay the course, work with the EEOC, see it through. The employers prevail in 76% of the allegation complaints. The charging party or person with a disability prevails, means their case has merit, in 24% of the cases. So 3 out of 4 times the employer is going to win. Just be quiet, be calm, let the EEOC investigate, work with them. An employer's odds are 3 and 4 that they're going to prevail. And that's without involvement of large expense attorneys and so on. Regrettably, only 24% of charging parties win their case. And I can also add, even though it is a bit of an aside, that 24-25% win rate is the same that you have in the Civil Rights Act for employment discrimination, whether it's women, whether it's race, ethnicity, religion, age, sexual orientation. A complaint is solved in favor of the charging party about 1/4 of the time. So in that sense, the ADA is in good company, very similar in terms of how discrimination behaves to other protected classes. Excuse me. Can we predict outcomes? I've already answered that. So for example, things you find out is the merit rate, if you're, the issue is hiring and the subject is male and has a physical or sensory impairment, is very high, much higher, like 35% compared to 24%. Merit rate is very low when we're talking about firing people for almost everybody, regardless of their impairment. It's well below 24% because when it comes to firing, employers are very well defended. They have cause other than, they have cause for letting people go other than the existence or consequence of a disability. The exception to this, ironically, is that the impairment group that prevails the most for unlawful discharge are people with alcohol and drug abuse conditions. Finding number 5 is kind of creepy. It concerns disability harassment and intimidation. So if I were to ask you this question, you might want to take a guess. Can you give me 3 impairment groups that experience the most actual disability? In other words, have the highest merit rate when it comes to harassment and intimidation. Now, harassment and intimidation for disability harassment is the same definition as it is for sexual harassment. Just switch out the words gender and disability. And we all know that sexual harassment or disability harassment is a pretty creepy, and I call it insidious, process. Nobody likes it really, nobody approves of it. But who in the disability world has the highest merit rates? And this is the answer to that question. People with intellectual disabilities, people with brain injury, and people with deafness. Now, think about what they have in common. Each of them is limited in terms of their capacity to process certain information, to understand clearly certain communications, to know they have cognitive problems, they have sensory problems that limit or distort the information they receive. They may not know that they're even being intimidated or harassed or think this is normal or think that it's just a joke. If it's insidious for women in general or people with disabilities in general, how much more insidious does it have to be that these vulnerable populations would be the most affected? And they most often win their cases on disability harassment compared to the other 45 impairment conditions that exist. Interesting finding. Here's an interesting slide. It looks very busy, but I'm going to get through it very quickly. On the left, you see a list of right to work states. And you may as well also call them red states because they line up that way politically. On the right, you have a list of union security states. These are states that embrace and don't impede labor's right to organize. There's about 25 states of each. You know geographically where they're distributed. The question is, who gets more discrimination allegation activity? A right to work state or the union security state? And the answer is the right to work states receive far more complaints of disability discrimination than union security states. In brief, for every 100 complaints received in a union security state, the right to work state with the same size, number of workers and industry patterns would receive 167 complaints. So there are about 60% more complaints filed in right to work states than in union security states. We have yet to publish this. When we do, there's going to be fireworks, but it's going to be a great story. Okay, so those are some interesting facts we learned. Now let's talk about people with deafness. What we have here, what we're comparing in this study, very simple study, is people with hearing loss, including from hearing loss to profound deafness. We're comparing about 21,000 closed allegations from the deaf community against about 340,000 from involving all known physical and neurological disabilities. So the target group is hearing loss. and the comparison group we call GENDIS, for general disability. What we do know is they're not addictions, they're not mental health, they're either neurological or physical, and we know that they have those conditions. Hearing loss, we know they have those conditions. So hearing versus GENDIS, hearing versus GENDIS. The pre-ADA years were 17 years from 1992 to 2008. The post-ADA years, 2008 to 2016. The magic date was January 1st, 2009. I'm sorry, that post-ADA should say 2009. January 1st, 2009 is when the amendments went into effect. And you say, well, aren't there, much more allegations in the previous years because there's so many years? Yes, but not proportionally so. In other words, if you look up at hearing, for example, you have 12,000 pre, only 9,000 post. That's because 9,000 is spread over only 9 years, not 17 years. But on a proportional basis, the activity has gone way up in those 9 years because of the amendments. That's exactly the type of effect, by the way, that Congress intended to have with the amendments. Again, isn't it nice to know that 100% of all senators and 97% of all House of Representatives and President George Bush all favored the amendments without any dispute, without any arguments once the case got to them and once they understood it. And it was these data that helped them understand it a little bit better. So here we go. Just look at charging party characteristics. If you look at the columns, hearing and hearing, pre is on the left, post is on the right, the split date is in the middle of January 1st, 2009. You see when it comes to gender, prior to the amendments, you have hearing is 57% male, and hearing post drops to 46. Both the male categories dropped, whether it was GENDIS or hearing. Follow the males across, and you'll see big drops after the amendments. Look at the females. They were in the inferior number position, 43, 47. They jump to 54 and 56. How could you have the genders flip-flop like that? And it seems like a mystery. And the only explanation we have to offer you is if you know, if you are a labor economist and you study these matters, as we really did study the effects, as we said, of the Great Recession from 2007 to 2012, it became known, disability or not disability, as the he session. In other words, male workers were adversely affected far more than females, about 50% more than females in terms of the unemployment rates. So you had huge drops in the labor force post ADA amendments because it coincided, January 1st, 2009, with the heavy weather days of the Great Recession, also known as the Great He Session. What about age? You see the age of the hearing people went from 43 to 49, whereas the age from the GENDIS people went from 45 to 46. If you look at the whole database, it usually nests around 45 to 46. What happened in deafness that older people, the age jumped by 4 years? That's a huge leap in terms of the age of people filing their complaints. The only explanation I have intuitively, I can't prove this, so you need very different kinds of research approaches to prove these things, is that this is some generational learning. In other words, the same people who were 43 years old, the same deaf people who were 43 years old before 2008 and earlier are now older, 49. They're carrying with them their ADA knowledge and their ADA activity and their ADA literacy and expertise, and they're filing. whereas other groups of disabled people are more or less constant. A big change in African Americans and the deafness group. Look at hearing, African American 13% up to 19%. So much more diverse, much more activity coming from African American deaf people. In genders, also much more activity from African Americans, 21 to 32%. So the African American share of people from genders was always much higher than the hearing population, but things evened out a little more, but still there's a real underrepresentation of African Americans in the deaf community who are filing allegations. Personnel actions, these are our issues. These are, again, the fun and sexy issues we like to look at. And we're just going to take these four: firing, reasonable accommodation, hiring, and disability harassment. And there's few things we note about them. First of all, there's consistently and significantly less firing and related allegation activity and less reasonable accommodation activity in hearing than in genders, regardless of whether it was pre or post. And that's very, very good news, because this is where you have to ask yourself, are these allegations good or bad? If you're having less activity in these areas, you're experiencing less discrimination. So that's a good thing if you're just looking at the frequency of the allegation activity. Remember those 823 values, 823,000 values, those are not people, those are allegations. Those are not people, those are allegations, and people can file more than one allegation. So they're doing very well, but they did increase their allegation activity on reasonable accommodation. But in firing, very stable. On reasonable accommodation, still pretty stable, and always less than a huge comparison group called genders. What about hiring? They're having much more, deaf people are having much more discrimination activity under hiring. Before ADA amendments, 16% to 8%. After ADA amendments, the gap narrows 12% to 10%. For deaf people, it's nice to know the hiring level of discrimination has gone down because of the amendments. That's the intent of the amendments, is to get more people hired. And it is getting better, and it is likely getting better because of the amendments. Harassment and intimidation, before 10% to 8%, favoring the deaf. After 13% to 10%, still favoring the deaf. So bad news here. In harassment and intimidation, despite the amendments, harassment and intimidation for the deaf went up against the benchmark group in both periods, but against itself in terms of pre and post by 30%. Again, when you see 10% and 3%, you can't say, what's the big deal? It's just 3 points. No, that's a 30% increase in relative value of the discrimination activity. That's a very large. Here you have the merit rates, who wins and who loses. And hearing wins more often than genders, but it did more so prior to the ADA amendments. When you look at these rows, look at the middle column, it says merit, and just jump right down to the red figure. That's total merit. So before the amendments, you see the deaf people outscoring the Gendis people 27-22. This is a race you want to win. They're winning their cases 5% more often than the general population. You go over to post amendments, still 27, but good news, the Gendis is catching up, 26. So the merit rates are staying the same or going up for everybody, and that's a good thing, and that's the intent of the amendments. You want people to bring forth cases that have merit, which means they're deserving. They're not just a perception of I've been discriminated against. They're not just my imagination. They're not just my misunderstanding of the law. These are actual discriminatory events. Those are the things you want to see reach the EEOC and be adjudicated. And you want to see people getting more than those 24% rates. So in non-merit, Gendis outnumbers hearing before and by a little bit after the ADA Amendments Act. An interesting column is this administrative technicalities on the bottom row. Notice before they were 9 and 11% for the two groups. Afterwards, they both dropped to 6%. That's wonderful. It means the Amendments Act made the law more clear, more understandable, more efficient, easier to regulate, easier to participate in, and the amount of closures for technicalities, a case closed on a technicality as it was in the process of the investigation, were going down. So that's just very good for the law in general. Non-merit means insufficient evidence that discrimination occurred, and again, employers are still winning 3 out of 4 times. But there's good news. The settlements are up. Those are happy times for both sides, employers and charging parties. The technicalities are down. Those are happy times for both parties as well as for the EEOC. The amendments are working. The EEOC is happy. The employers are happy. And the charging parties have cause to be happy. Sometimes the deaf, sometimes not. Depends on the issue and the merit rate. So that's what the study shows, and it's just an example of these 90 studies. We do this study in honor of the late and great Frank Bowe, who with me published the first study on deafness way back in 2005. This is sort of a replication, obviously from 2005 to 2016. You added a lot more cases and we have a much clearer understanding. Frank passed away about 8 or 9 years ago, and we did this in his memory and to honor him and see that his work continues. He and I were good friends, and he's a great, great leader in the deaf community, for those of you who don't recognize the name. Another article that relates to this came out in 2018. Here we took two distinct we took a very different approach to analyzing the entire database, and we just looked at patterns of discrimination against broad categories of disability. So we just looked at the whole situation like this. How is discrimination different for physical disabilities, behavioral disabilities, neurological disabilities, and the 2 sensory disabilities of deafness and blindness? And the answer was, there are no differences in the first 3, but the 2 sensory disabilities, deafness and blindness, were very different than all the 3 other broad category disability groups in terms of the issues and in terms of the merit rates. Very different. They experienced deaf and blind people and deaf-blind people experience discrimination very differently than other disabilities. And there are interesting ramifications of that, because in disability world, where there's all this concern about the cross-disability movement. They'd like all the hundreds and hundreds of consumer groups, advocacy groups representing specific disabilities to kind of merge and do things that benefit them all. and share their resources. And I've always been myself a strong proponent of this. Break down these silos, break down these walls. Let's, represent yourself as an economic force, as a political force. Think in terms of your membership in the disability community as brothers and sisters with all other disabled people nationally, globally. We've always been on this banter. But in the case of the study of discrimination, we have this situation, let's say in state vocational rehabilitation here in the United States, where there's a voc rehab agency for everybody, but a separate voc rehab agency for the deaf and for the blind. And that's been a source of enormous controversy. But as we come to understand how they experience workplace discrimination so differently, maybe there's room for that, or maybe there is a place for that. Because one of the great inhibitors to the labor force participation of Americans with disabilities is job discrimination. So that's very interesting. And it led us to say, let's look deeper into sensory disability. And so we have this article coming out in the first quarter of 2021. It is in press now. It's going to be in a special issue of the NCRE journal, Rehab Research Policy and Education. And it's about the Helen Keller question, as we call it. Helen Keller was oftenly asked if you could have your hearing back or your vision back, which would you prefer? And quite surprisingly to most people, she said, I'd rather have my hearing. And most lay people would rather have their vision back, but not understanding disability or being people with both disabilities. Many, if not most, deaf blind people, if they could have one back, would want their hearing. And among the reasons were, it will help me more with obviously speech, and I can enjoy music. Well, that's a somewhat superficial distinction. That's not really what we studied, but we did study how deaf and blind people, how deaf people and blind people experience discrimination differently in that article. If you have interest in this line of research at all, or would like to have a bibliography of all the research, you can email me, of course. My email, I think, is on the first slide. You can download my research. You can text me on my cell at 804-240-4587. You can download my research on ResearchGate. There's a link there for you to do that, and you can just get PDF reprints off of that site for about, I don't know, if we've got 90 things in press, probably about 75 or 80 are available to you up there, as well as to all those other authors that work with us. That concludes my remarks. And if some folks have come in or and have any comments to offer or any questions, not just about deafness, but about ADA in general, or any comments to share with me, I think Mandy is willing to moderate those, and we can process those at this time.
Okay, thank you so much, Brian. So for those of you who are tuned in currently, if you have any questions or comments that you would like me to share with Dr. McMahon, please enter them into the question box, and I would be happy to relay them. I would like to just extend a thank you to Brian for presenting on this topic. I have a whole notebook of notes that I was taking while you were presenting. I was learning a ton as I was listening to this, and we are just very fortunate to have your expertise here for this webinar, so thank you so much. I have a question. I'll get the questions started while I give people time to type in any thoughts. We have a lot of thank yous coming in. So back on one of the slides where you had mentioned that there was actually I'm looking back at my notes, the increase in harassment and intimidation for individuals with deafness being imposed. Do you have any speculation as to why those numbers went in that direction?
Well, I think, yes, I think, remember the representation of the deaf people who are women filing flip-flopped from 45% to 55%. And so you now have more women who are deaf making complaints, and women who certainly are likely, because of, the Me Too movement, which is not just really 3 years old, but I mean, there's been so much more attention to sexual harassment and intimidation that, they're more literate and certainly probably more experienced with that, either themselves or through family, friends, loved ones. It's an issue for them. So I think the resurgence of women who displaced a lot of people during the recession, the Great Recession, probably accounts for some of that increase. But harassment and intimidation complaints, even outside of disability world, for all the other protected classes, are escalating substantially for gender, simply because of the change in our culture about the, not just inappropriateness, but let's go back to that word, insidiousness of this behavior and the real serious damage it causes to people.
Thank you. That certainly makes sense. Okay, and so you shared a little bit about this upcoming publication regarding the Helen Keller question and the analysis there. And there, of course, are these 90 publications that are either available now or in process. But would you like to share more about what is next for you in terms of further research and projects?
Well, we usually, sit back and wait for some researcher that, learns about this and needs a dissertation. That's those of us like you, those of us who have PhDs or have been educators, as I have for 40 something years, know that you can get a dissertation done in a year, or you can get it done in 5 years. These dissertations take 6 months because the data is there, and universities are much better about accepting existent big data studies if the analytics are right and if the database is verifiable. And and not only that, these are population statistics. You don't even have to infer back from your sample to your population, because this is what is actually happening with the entire universe of reported discrimination. The limitation being, of course, we can't capture unreported discrimination, just like you can't capture unreported crimes of any kind. Next for me is whatever other people want us to study. My job is to extract the data for them, to guide them. Usually they're the content expert. If it's about a disability, if it's an employer interested about what's going on in their industry, if it's about labor unions, if it's about the interface of gender and disability, the interface of race and disability, we honor their research question and help them, package it for them, so that literally in, a month or so, you have your findings, and you can begin doing careful work on your implications and conclusions. And but database mining, as you know, Mandy and Karen and those of you out there who are academics, is about generating research questions. I mean, more questions are generated from this research I presented you today than are answered. And those have to be handled in, other ways, either in terms of qualitative research or clinical trials. And all this data, at the EEOC has to be de-identified so that there's never a way, not just of identifying any individual charging party, but they would shut this project down tomorrow if a particular employer were identified. So, it's a lot of fun. There's a lot of knowledge we're getting, new knowledge we're learning. But, I'm about to retire soon and kind of scaling down. But Dr. Rumrill, who's been a deputy to this project, is taking over this project at the University of Kentucky. And I'll just do whatever he asks me to do as best I can and as long as I can.
Excellent. Well, since Dr. McMahon has just announced that he is retiring soon, I certainly encourage everyone who's listening to this webinar to send your questions to him sooner rather than later. So he's an absolute treasure to this field. And so please, his contact information is over on that first slide. And if you have questions or comments, please do follow up.
By all means. Are we done then today?
We are all set. I'm going to conclude the webinar. So thank you, and thank you to all of our listeners.
Thank you very much, Mandy, and everybody else. Bye-bye.
Take care.